May I please, Your Lordship? Your Lordship, in item number 6, Your Lordship, LCR was called for, that is received by the registry as I have taken the instruction, Your Lordship, but that is not tagged with the record, Your Lordship. So matter may be taken up after tomorrow, Your Lordship.
At?
Item number 6, Your Lordship.
No, that's all right. We have to call for the record.
Yes, Your Lordship, that is received already, Your Lordship.
Okay. Okay.
Lordship.
Tomorrow, day after tomorrow.
Day after tomorrow, Your Lordship, is possible, Your
I
Lordship.
have to.
Okay.
I have a different code.
So the pair being made by Mr.
I.H. Lashkar.
I.S. Laskar, learned counsel for the petitioner, SSL is the matter, day after.
Fine, Your Lordship.
Yes.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 16 and 17, my lord. I'm appearing on behalf of Mr. G. Rahul, my lord. He's out of station, my lord. Therefore, matter may be adjourned for at least 2 weeks, my lord.
You inform the other side?
Yes, yes.
Lordship, I am for the respondent.
I am appearing for item number 16, Lordship, for the petition.
Already informed.
Mr.
As doctor, on
S.
behalf of
Doctor, learned
Mr.
counsel for
G.
the
Rahul.
learned counsel appearing on behalf of Mr.
G. Rahul.
G. Rahul, learned conducting counsel for the petitioner,
In item number 17.
item number 17 and in 16.
16, my lord, is connected, my lord. Already, yes.
With consent from the other side, first for listing the matter when?
After 2 weeks, my lord.
After 2 weeks.
Date may be fixed.
Maybe fixed in the month of June, Lordship.
After 2 weeks,
Yes.
on 12 June.
Lordship, an earlier date, Lordship, kindly.
Thursday, 12 June.
12 June, please. My lord.
Items for admission, part third matter, item number 1.
My lord, the Bar Council of India was supposed to file affidavit regarding.
This is the last chance, my lord, that was given to the long pending case. After initially they declined to file affidavit. But
Who is appearing
subsequently-
for bar counsel?
Lordship, in accordance with the instructions, we are not allowed, we are not directed to file affidavit in our opposition by Bar Council of India.
Yes.
We don't have any direction.
But this, my lord, in last occasion, they are saying that there is an instruction, they are going to file affidavit. And now they are saying that they have no instruction to file affidavit, my lord. Unnecessarily matter has been dragged. Whatever may be, my lord, lordship may, my
We will
lord.
proceed to hear the matter without your affidavit.
Yes, my lord.
Priya,
My
Lord.
lord, my lord, the matter may come up on Friday. By this time. Lord, if, there is-
My lord, it is very difficult, my lord, all the time, because when lordship, I approached the Supreme
No,
Court also.
why on Friday?
My lord, since my lord, I thought my lord that Bar Council of India will file affidavit.
No, she has stated that she has no instruction to file affidavit.
There is a crucial aspect, my lord. So it is, the matter may come up, this. on
Friday, I don't think, but that will be possible, but unless it is in hearing day, but that will be Thursday, my lord.
On Thursday.
Thursday.
Thursday is the first item, my lord, at least, my lord, the matter is to be disposed of. Pardon.
Third Mr. P. Monson, learned counsel for the petitioner, and Mr. P.J. Kupun, learned extending counsel for the
Got in.
Guwahati University, and Madam, your good name, please.
Embargo Hai,
For
For Bar Council of India.
Bar Council of India.
Bar Council of
India.
India.
On behalf of Mr.
And-
Hemant.
UGC. On the pair being made by Mr. Kupun, learned standing counsel for the Guwahati University. The matter stands adjourned to be listed on Thursday.
My lord, my one prayer, my lord, as they are saying that they are, my lord, no instruction to file it, that should be, my lord, recorded, because, my lord, earlier occasion, they are saying that they have instruction, then subsequently they came with another stand, that they have no instruction, that should be reflected, without their affidavit, that should be considered, my lord.
Okay, on that day, in the event of failing to file any affidavit by the BCI, the court will proceed to hear and dispose of the matter without the affidavit.
Item 2.
May I please, Your Lordship? My lord. He was supposed to obtain,
Instructions are awaited, your lordship. Instructions awaited, your lordship.
and then earlier several times they took time for instruction.
Also, instructions were placed, your lordship. The Lordship, the up-to-date instructions is awaited, your lordship.
Up to date instruction in respect of what?
Lordship, in respect of creation of post with regard to the petitioner, your lordship.
The petitioner has not been appointed due to want of retention of the post.
Non-retention of the post, your lordship, and so our department had written to the government that since the post is vacant, your lordship, whether the petitioner can be adjusted against that post, your lordship. So a query was made by the government to ask to the director whether there has been any post creation order, your lordship. And on the last occasion, I had placed, your lordship, that there is no post creation order. But there is a post vacant, your lordship, and his post is required. The service of the petitioner is required in that school, your lordship. So in that way, the instruction was, the query was answered, your lordship. So on that, there is no up-to-date instructions from the government, your lordship.
Okay, next week then.
Next week, your lordship.
Last chance maybe.
Or Mr. M. Khan, Learned Counsel for the Petitioner, and Madam Musari
Yeah,
for
hello.
the Secondary Education Department. Ms. Musari submits that up to date instructions are still awaited and placed for listening the matter after a week. Parallel, this list the matter
On 23rd.
on.
Oblast.
Okay.
Item 3,
Please, your lordship.
Hmm.
My lord, this matter is covered by the latest judgment on compassionate appointment, my lord. This is the pending case, my lord. Before this honorable court.
Hmm.
This is the judgment I have brought, my lord. The last sentence is it shall only apply to cases that are pending before this court as on 3/4/2025.
Notice is yet to be issued.
My lord, here, my lord, notice was issued. Notice was issued and we already taken steps, my lord,
Notice.
on 18/12/2023, my lord.
Okay. Now, what is your prayer?
Prayer is, my lord, to place the last communication is page 20, my lord. Thereafter, there was no communication from the department, my lord.
Yes, sir. Where is the affidavit of the state respondent?
No, Lordship, affidavit has not filed, Lordship. But Lordship, this case is considered as per the direction given by the Honorable Supreme Court in Debabrata Tiwari cases, Lordship. Is on 2002, Lordship, the petitioner's father was died, Lordship. 2002 meter, Lordship. The long.
And he applied on 11/7/2005.
But
At that time, there was no time frame, my lord.
no.
At that particular, because the Achyut Ranjan's case was on 3/8/2026, my lord. And the petitioner applied on 11/7/2005. The application I have annexed, my lord, page 18-19, my lord.
Paragraphs 35.
That's all right. But recently, some decisions were, no, some judgments were passed by
The coordinate bench, Lordship.
regarding
My lord,
Lordship.
all
this
the
is the
assurance
judgment,
given by
my
the
lord.
Advocate General.
Abdul Qadir Boxi, Lordship.
This is the judgment, my lord. The last sentence, your lordship may kindly peruse, last paragraph.
This is WPC 342/2025.
The last sentence, my lord, this covered by this. The last page and last sentence, my lord.
Which one?
So, we may pass similar order in this case also.
Yes, my.
Is there any objection on behalf of the state respondents?
Lordship, it may be Lordship because but in Abdul Boxi case, Lordship, I think you referred which one?
The judgment,
No,
the
which one? Which
not
judgment?
particular case. This is a series of cases.
No, no, yes,
Series of
no, no.
cases. And the
The-
last sentence says that this.
Abdul
uh,
Kadir Boxi, yes.
Abdul
this-
Qadir Boxi.
this
If
petition-
we go through the Abdul Qadir Boxi's case, Lordship, it is WPC, Lordship. Here in this case, WPC, Lordship, WPC 342/2025, Lordship. Abdul Qadir Boxi.
Yes.
Yes. Here, the principal said that if the pending for one-time consideration, Lordship, it may be referred, Lordship, in on this principle, Lordship. So it is stated that paragraphs 10 here in this case, paragraphs 10 is not last, paragraph 10.
Last
It-
paragraph
no,
and last sentence.
No, last paragraph
Last
is
paragraph,
11.
para 10.
Last paragraph is 11. I refer 10, paragraph 10. It is made clear that in the view of the consent of the parties, the court has not gone through the merit of any petition. It means that petitioner's lordship. It is not related with this case.
But there is one
That
sentence that it
petitioners.
is covered all the pending cases before this honorable court. The last sentence, your lordship may kindly peruse.
Be it considered
Last sentence to
it
follow.
again made clear that
Matter pending before
cannot
this
be
court.
used for the precedent of the cannot be used for the precedent of cases that are filed on 4/4/2025. Therefore, yes,
No, this petition was filed prior to that.
Lordship,
Yes,
It
my
is
lord.
of 2020.
it may be disposed of.
Okay, in this line, we will
Yes,
dispose of that.
Paragraphs 10, Lordship. They wrote the theory also
Okay.
deliver it there.
At number 4,
Obliged.
yes, please, your lordship.
Yes,
Lordship, in item number 4, my lord, on behalf of finance department, I am seeking some further time, my lord. Some more time to file our affidavit.
okay,
My lord, we have misplaced the file, now we have reconstructed, my lord.
okay.
Hmm.
None appears for the petitioner on call. How about Mr. Borpuzari? Learned Standing Counsel for the Finance Department, and Mr. Sarma for Elementary Education Department. Present Mr. Borpuzari submits that he may be granted some time to file the affidavit in opposition.
My lord.
Where stands allowed, leave the matter. You, Mr. Sarma and Mr. Borpuzari both press for granting them some time to file the affidavit in opposition. Where it's allowed, this is a list the matter after 2 weeks.
My lord, can it be 3 weeks, my lord, with all respect, my lord,
Okay, 3 weeks.
my lord.
Item 5.
May it please your lordship.
Yes.
Out of same FIR, 2 petition is fixed on 16 lordship this
Hmm.
month. So in that is a BA of
16 of this month.
this month, lordship.
You want this matter to be listed on that day?
Lordship. Already LCR received on that case, lordship.
Okay. Heard me, sir?
Yes, Hussain,
S.
Hussain lordship.
S. Hussain, learned counsel for the petitioner, and Mr. Kosik. Your name is not there.
Lordship, actually, my name is actually BLESK, but in the meantime, I have changed my name to Sanu Hussain lordship. So now it's S Hussain lordship. That's it.
Okay. It is submitted at the bar that in connection with the same subject matter, another petition being bail application, another
Bail
bail
application
application
BA oblique 174 of 2025.
BA or AB?
BA lordship.
BA.
BL.
BA
174
174 of 2025
25 lordship.
is
And another is also there, lordship. BA of 334 of
I
2016,
think before this court, and the matter is listed on
lordship.
16. And in the said matter, the LCR has already been received, and as such, this matter may also be listed on that day, along with the aforementioned bail application.
Lordship,
There is
one clear lordship. Lordship, in the course title, typical error, Lordship. Special case number 41 of 2025, which should be 41 of 2024, Lordship.
You follow the notification issued by the registry for correction of construction.
Lordship.
Place the matter on 60.
Problem.
Item 7.
Lordship, POCSO matter, Lordship, in this case,
Notice,
notice served, Lordship, may appoint amicus to the
notice served, my lord.
Notice, sir.
Lordship.
No one appears.
No,
No
Lordship.
one appears. Amicus may be appointed.
Amicus. Okay. Heard Mr. L.R. Mazumdar, learned counsel for the petitioner, and Mr. Koksik for learned additional opinion for the state respondent. Mr. Koksik submits that notice upon the respondent. Number 2 has already been served, but no one entered appearance today. Accordingly, it is provided that Mr. S. Viswas be appointed as a legal aid counsel. Sumit Viswas. As legal aid counsel for respondent number 2. This shall reflect the name of Mr. Viswas in the call list and also furnish the relevant papers to him well in advance. Place the matter on Friday,
Lordship, next week, Lordship,
next week,
any,
21. Okay.
of like,
CDB retained, my lord.
Till then, CD will retain.
of like.
Hearing, item number 8, partner meeting.
In this matter, Mr. PK Bora. Dear Lordship, and he has some difficulty today. He's unwell also. The Lordship can fix on Thursday. He has requested Lordship.
Thursday,
On Thursday, Lordship. Some difficulty.
Thursday, we have lot of cases.
Then after next Tuesday.
Lordship, if I may submit, Lordship, if Lordship may recall, on the last occasion, I have already submitted and I was complete with my submissions and arguments. And from the other side also, he was also completed with his oral submissions. Only thing, if your Lordship may peruse the judicial order last past, Lordship may see that it was only he said that he will be submitting some written submissions because I on that day filed. So your Lordship said that.
Lordship, I'm told that some judgments also he is going to place Lordship.
Okay,
So,
Lordship, in that
next-
case, Lordship may fix.
Next Tuesday, Lordship, in that case.
You have already submitted.
Yes, everything is finished from my part, Lordship.
Okay.
Counter was done.
Third is as IDAS learned counsel for the petitioner and Mr. P. N. Sharma learned counsel appearing on behalf of Mr. Bora, PK Bora, learned standing counsel. Submits that Mr. Bora has some difficulties today and press for listening the matter on 22nd.
Lordship.
This is a list the matter as part of.
Deeply obliged.
Item numbers 9 to 11.
Mr. Nayak, this matter is of 2012.
Yes, Lordship. Lordship, I am. taking the
After
brief.
2014, for the first time it is listed today.
After 2012, I think first time it got.
No, 14.
14, Lordship. Lordship, in these matters, Lordship, I am not having my briefs, Lordship, I am going through the court's brief. Petitioner is also not appearing. It appears, Lordship, it's a matter relating to reservation in promotion, Lordship. So that, so far as other backward classes are concerned. Lordship, that issue has already been decided by our honorable court, Lordship, by a single bench as well as the division bench. So if Lordship permits, Lordship, probably petitioner is also not interested. I would definitely like to have a copy of this petition, Lordship, by applying certified copy. And Lordship will take up this matter in the next week or after 2 weeks, Lordship.
After 2 weeks.
Then Lordship will dispose of this matter.
Okay, none appears for the petitioner on call. However, Mr. Nayak learned standing counsel for the respondent authorities. Price for listing the matter after a week.
After 1 week, Lordship.
1 week. Fair is accordingly allowed. This is a list the matter on 29.
Lordship.
29. Mr. Nayak, we are sending the date. 22nd.
22nd May. Lordship.
Number 12.
My lord, this matter relates to claiming from my lord pension. In view of the my lord amendments, certain amendment has been brought to the CCS pension rule by a office memorandum, my lord, in the 2008. By which my lord 0.53, my lord, in case my lord Natsel, my lord, I am submitting my lord, the petitioner, he was my lord, initially appointed as my lord as my lord in 95 as overseer in grave, and subsequently after completing more than 13 years in service and posted in different places, he was promoted to the post of the my lord. This is Superintendent BR grade 2, which is equivalent to junior engineer. And after serving in 13 years of service, my lord, he decided to resign from the service because of considering his ailment of his mother, because he was the only son to look after his mother. So after the retirement, as per the old CCS pension rule, he was given the benefit of all gratuities and the leave encashment. But while paying the leave encashment, that was accumulated for 124 days, they have only paid 40,000 rupees, my lord. That was expected that would have been my lord, more than lakhs of rupees, but that was not paid. Only 40,000 was paid. But by this time, what happened? Well, the government of Assam, well, this is pension and public grievance department, government of India Ministry of Personnel and Pension and Public Grievances, my lord, they have brought some amendment into the CCS pension rule. This is 49(2)(b), by which my lord OM dated 2nd September 2008, 0.53, they allowed the person who has served minimum 10 years of bona fide service for entitling pension. They are entitling 50% of the total emolument last drawn as a pension, my lord, or other benefit whichever is
Whether that
Yes,
notification is on the record.
my lord, no, I am there, my lord. Kindly come to my lord. I have mentioned in the prayer, in the petition, body of the petition as well as my lord. I have annexed the document also. This is my lord, Annexer 3 at page 37, my lord.
Annexer
3 at page 37.
37. Yes.
Lordship, kindly come to 0.5.3, my lord, is page 40. Wherever it is stated, in case where the government servant became entitled for pension on completion of 10 years of qualifying service as according to
5.3.
Yes, madam.
Okay.
Page 40, madam.
Yes.
It is stated, but in case where the government servant became entitled to pension on completion of the 10 years of qualifying service in accordance with the Rule 49(2) of the CCS Pension Rule 1972, pension in those cases will be paid 50% of the emolument on average emolument, whichever is more beneficial to the government servant, my lord. By which, my lord, the earlier pension rule, that was, my lord, 49(2)(b), it is saying that on completion of the qualifying service of 10 years, they were only entitled for pro-rate pension, my lord, not full pension, my lord. On the basis of the what salary, my lord, they drawn at the time and the other calculating the things that the pro-rate was given. It's not a my lord, full pension. So by this amendment, the government of India, my lord, the Pension and Public Grievance Department has brought some amendments for the benefit of the person who are retiring from service before completing the tenure, full tenure, mid of the service, but after completion of minimum 10 years of service, by which they were entitled for a full pension. Then on the basis of this office memorandum, whenever it was brought into existence and the gazette notification, the petitioner has filed one application. So for consideration, this benefit to the department concerned, by filing his application, that is Annexure 4 at page 56, my lord. This was the application filed by the petitioner before the authority concerned. And on receipt of this, my lord, they kindly turn to next page, this is 58, Annexure 5. My lord, the prayer was rejected.
Page number?
Page number, my application was page number 56.
No, that's all right. The rejection order.
Rejection order is Annexure 5 at page 58. 58, my lord.
Annexure 5.
Annexure 5, page 58. Next page, my lord. By which they saying, my lord, the letter, my lord, my application was rejected by the DGBR by this letter dated 12 October 2010. Lordship will get in this context, it is intimated that your case was taken up with the headquarters DGBR through the headquarters such Udayak by letter such dated such regarding the admissibility of the pension in your case. In turn, reply has been received from the headquarters DGBR by their letter dated dated 12 October. You are not entitled to pension. Photocopy of the headquarters DGBR letter was enclosed here. But in fact, this letter was not communicated to me on what basis my claim has been turned out by the DGBR. So again, I wrote to the department concerned to furnish the copy. So ultimately, they in 2013, they furnished the copy, my lord, that by which the DGBR 12 October, Lordship will get in the next page, in the 59 page, Annexure 6, by which my right for pension was rejected by the DGBR. That was communicated by the administrative officer, General Border Roads, by which resignation from service required for pension. Reference your headquarters letter such as per the existing rules, a government servant quitting and resignation will not be entitled to any pension, gratuity or the termination benefit. In the instant case, the individual proceeded on resignation into his own volition on such as per Rule 26(1) of the CCS Pension Rule 1972. The resignation from the service or the post entail the forfeiture of the past services. So accordingly, I am not entitled for the pension. But my case is although this provision is there, that on resignation, the person is not entitled and is entitled the past service benefit, my lord. But in my case, my lord, there is some exceptions, my lord, because the lordship will, I have quoted the provision of 26 also in my body of the petition. Yes, ma'am. Lordship will come at page 70.
70.
No, 17, ma'am. Body of the petition, ma'am. I have quoted the provisions of 26, under which they are saying that they are entailing the past service on resignation by the concerned officer, madam.
Para number?
It is lordship will come to the bottom. It is para Rule 26. Lordship
Rule 26.
Got it, my lord?
Yes.
But the way it is, forfeiture of the service on resignation. One, resignation from service as or a post, unless it is allowed to be withdrawn in public interest by the appointing authority, entail forfeiture of past services. Then second, my lord, a resignation shall not a resignation shall not entail the forfeiture of the past service if he has been submitted to take up with some proper permission another appointment, whether temporary or permanent, under the government where the service qualifies. Interpretation in the service in the case of the filing under sub-rule 2 due to take to two appointment being in a different station, not exceeding the joining time permissible under the rule of the transfer shall be covered by the grant of the leave of any line due to the government servant on the date of the relief, or by forfeiture condition to the extent to which the period is not covered by the leave due to him. Then my lord, come to 4, my lord. The appointing authority may permit a person to withdraw his resignation in the public interest on the following conditions merely. Namely, that the resignation was tendered by the government servant for some compelling reason which did not involve any reflection on his integrity, efficiency, or conduct, and the request for the withdrawal of the resignation has been made and result of a material change in the characters which originally compelled him to tender the resignation. My lord. In this case, my lord, I was compelled because all my representation that will reflect in my application also that the compulsion that my mother was, my lord, ailing at that time. So there was no person to look after. So under that compulsion, I my lord, sought my resignation from the department concerned. So in this respect, my lord, this condition, if it is, my lord, they relying, they for, my lord, they have not, my lord, given any such sort of, my lord, benefit to me as per the condition to do withdraw the resignation, my lord, because I was in compulsion at that time. So considering that respect, my lord, I am entitled to get the full benefit, though that was not given to me by the under the provision of the old CCS pension rule. In view of the amendment brought by this new office memorandum, this is 5.3, my lord. So my case is a very simple matter. I am entitled for the at least, my lord, the full pension of the benefit in view of this new amendment. They were wrongly interpreted that I am not entitled, and accordingly, my lord, I should be given the benefit of the full pension, my lord. And so far the leave and encashment, that is going to more than my lord, 124 days leave encashment was accumulated, but they have paid only 40,000, my lord. This is much below the my all total accumulated, that is more than lakhs of rupees. That was, my lord, not given. They have been depriving to getting my leave encashment also. In this aspect, my lord, they have filed their affidavit. Other side, they same the same stand, whatever is the ground for rejection in my letter, the Annex 6 by the authority concerned, my lord. Nothing else.
Who is for the respondent?
Is a CGSC, my lord.
Okay.
SP Chaudhary, madam. I have to inform. Otherwise, madam, in our CGC, madam, case were allotted.
Sabyasachi, my lord.
SP Chaudhary, madam.
SP Chaudhary, well, he was always present earlier, but the affidavit also filed, but not that.
Well, I'll inform, madam. Just.
Is present in the court?
I have not seen today, madam. Just I'll make a call, madam, after some time, madam.
Okay, let him come then.
Well, Item 13.
Then, my lord, time is because another matter also at 2 mile fix the delivery order. So, my lord, I think after that matter will be completed, then I'll come, my lord.
F?
After second of my lord.
No, second now we don't have past method.
Then, my lord, you will inform. If it's coming, I'll be fine coming.
Ah.
My part has already done, my lord.
Okay, okay.
Item 13.
Adjournment for today, Lord.
Adjourn?
Adjournment
For
for today, Lord.
today. Why?
Due to some personal difficulty, my senior Mr. Cake was not the matter.
Madam?
Due to some personal difficulty, Lordship, Mr. Cake was not do the matter today.
Who is appearing?
Mr. Cake was.
Mr.
Cake was.
My lord, this case was heard by Honorable Mr. Justice A.D. Chaudhary on 2 occasions, your lordship, in their presence. Now, due to paucity of time, your lordship, judgment could not be delivered, your lord. Now, this is the 3rd occasion when the court case is being listed, your lordship, before your lordship for an hearing, your lord. And case is also very peculiar, your lordships, and facts of the case is covered by a Supreme Court judgment, your lord. Krishnakanto Parmar versus the Union of India. Case relates to, my lord, removal of the petitioner from service.
Okay, let it be on Thursday then.
Let it. Thursday, my lord.
Thursday
It
may
is
not be
Thursday.
possible.
Let it come of day after tomorrow. I will be here. Otherwise, my lord, I will have to
Day after tomorrow.
go, my lord. I will have to go, my lord, by Thursday, last day. my lord.
Okay, okay. Heard Mr. Endor, learned counsel for the petitioner, and also
Very
heard Madam
peculiar, your lord.
P Thapa. P Thapa.
P.
Thapa.
P. Thapa, learned counsel appearing on behalf of
The cake word.
Cake
Over
Ward.
that time, my lord, shall be
Learned
given, my
counsel for the respondent. Learned standing counsel for the respondent.
चार्ज तो नहीं बोला वो
Ms. Thapa, learned counsel appearing on behalf of Mr. Cake Ward. Learned conducting counsel for the standing counsel for the respondent authorities as for listing the matter on Thursday. Parallel. Let's list the matter on Thursday. Yes.
Well, this is case of dismissal from service of a CRPF, police constable, CRPF constable, my lord, on the charge of drunken state of affairs. So, my lord, last time also I argue, my lord, the charge level against is under section
Second 11.
11 of the CRPF Act, which prescribed for minor punishment. But now punishment given in measure. Because as your lordship knows, my lord, the armed forces who are to constantly guard the post, or not only 8 to 12 hours, sometimes 20 hours also. They get tired, they drink also and fall down. This is what happened here also. And on that charge, for drunken state in during duty, he was dismissed from service. This is the my simple submission is, since the charge is leveled under section 11, there is a minus punishment, but it was given major punishment. Number 2 is it is disproportionate. The Lord knows many of the judgments that in the force they drink. They have to drink, otherwise they cannot survive also. Because when one is, I have seen one in Kashmir, in Ladakh, the cold weather, the army was standing, and while we were taking food in a hotel, in a Pangong, Shanty hotel, small, one of the army Jawan fell down. Natural it is. So physical condition deteriorates. We cannot stand for 1 hour, but they are to with a rifle, they are to stand about 8 to 10 to 12 hours on duty post. So on under charge, you are dismissed. My simple prayer is that punishment is disproportionate. I brought old 2 decisions of Supreme Court also. And there are other High Court decisions, but I am guided by the Supreme Court decisions. So, Lordship, may kindly come to CRPF attention. Section 11. Section 11, my lord. Minor punishment. The commander or any other authority or the officer age may be prescribed, may subject to any rule made under this act.
Section
11.
Yes.
The commandant or any other authority or officer as may be prescribed may, subject to any rules made under this act. Award in lieu of or in addition to suspension or dismissal. In lieu of dismissal, madam. Any one of the one or more of the following punishments to any member of the force for whom he considers to be guilty of disobedience, neglect of duty, remises in the discharge of duty, or other misconduct in his capacity as a member of the force. There is a reduction in rank, fine or any of any amount exceeding 1 month's salary, not exceeding 1 month's, confinement to quarter guards, confinement in the quarter guard for not more than 28 days with without punishment of drill or extra guard, fatigue or other duty. Removed from any office for distinction or special emolument in the force. These are the punishment prescribed. Since he is the constable, there is no other lower post except the post of peon or chowkidar. So, and
The proceeding was initiated for minor punishment or major punishment?
the charge is under section 11. That means for minor punishment, since the charge itself is under section 11, my lord, also kindly come to charge.
Where is the charge memo?
Charge, my lord,
Annexure 1?
yes, Annexure 1, page 15.
Yes.
They dated 31/7/2018.
Section 11(1), violation of 11(1).
In the order itself, the charge is given.
Okay.
Office order. Department was instituted in the gentlemen in the post ornaments, along with the order, the charge is given.
So, as per subsection 1 to section 11, the punishment prescribes are minor punishment.
Yes. Yes.
So, initiating the proceeding under this section, you have been removed from service.
Yes.
Which is a major penalty.
Yes.
That is your complaint.
Yes.
Not remove.
Dismissal. Dismissal service. He has served, my lord, over 13 years. He is now only 41 years, my lord. When he was removed, he was 35. Normally, he is too young to sit idle and too old to get a new job. There is a Supreme Court decision, my lord. Perhaps his lordship's Justice Iyer, my lord, too young to sit idle and too old to get new job. This is his condition. Now he is working as a labor, my lord, day laborer.
So, what the decision states about this? Decision referred by you?
There should be proportionality commensurate with the offense. Commensurate.
That is the discretion of the disciplinary authority.
But
whether court can interfere with the same.
Yes, the court go and if it is disproportionate, my lord, then they will also certainly.
No. There are several decisions of the Supreme Court. Unless it shocks the conscience of the judicial conscience only, then the court can interfere.
Person following due to alcoholism, he falls down in the duty post. Even in the section 11, you will also can see what are the offences that are being punished with minor punishment. Again, I will also kindly come to subsection 1. The commander or any other authority of the officer, age may prescribe, may substitute any rule under this act. Award in lieu of or in addition to suspension or dismissal any one or more of the following punishments to any of the members of the force whom he considered to be guilty of disobedience. This disobedience in the force is very serious otherwise. There are disobedience. Neglect of duty is also very serious in for the armed forces. Or reminiscences in the discharge of any duty or other misconduct in his capacity as a member of the force. For such serious minor punishment prescribed. And what are the minor? Let's kindly come to first minor. Section 9. What are the more heinous offences? And section 10, where it will also kindly come to section 10, less heinous offences. In the less heinous offences, madam, is in state of intoxication when on or after having been warned for any duty or parade or on the line of march. Then, my lord, come to E. Is grossly insubordinate, it is not so insubordinate. Absent himself, no. So, he can be charged, my lord, for in a state of intoxication. This is less heinous offense. Less heinous offense, but the punishment is given for more heinous offenses.
No. He was not only in the state of intoxication, but he was unconscious.
Hello?
He was found unconscious.
Yes. Yes, my lord. Unconscious.
On the floor of the duty post.
Yes. That I have said, my lord. If your lordship wants to see the recent judgment, my lord, I will bring on any other day. Recent judgment on this particular point of this. These are old judgments. 83. Recent judgment of Supreme and our High Court also. Fix on next week, any day. Sir.
Yes, Mr. Parasar.
Otherwise, my lord, in my lord, may say order dated 17/3/25, my lord, Lanet Senior has stated that I have no case otherwise regarding some documents, original document with the department. If those documents will return to me,
The documents are necessary one because
now,
I could not give admission to my children.
now I have taken instruction and document with me, my lord. Otherwise, on merit, my lord, because of that argument, my lord, I have not actually thoroughly prepared on merit. Otherwise, I have filed the affidavit. My lord, his appeal also dismissed. All are there, and not because only intoxication condition, my lord. He is unconscious condition, and his LMG rifle was unattended, found unattended, my lord. He was in sentry duty. There is threat for the whole team, my lord. He is in Morsa sentry duty. His LMG rifle was unattended. He was found unconscious. Not only, my lord, that found in only intoxicated condition. But there are the serious and department. There is no lapses on the part of the department regarding the departmental inquiry.
No, you have initiated the proceeding under section.
Regarding that point, my lord, earlier not raised by Lanet Chiram, my lord, I'll definitely apprise you.
Let it come up.
When?
Any, my lord.
Okay.
Probably I did 2 more questions. Me, man.
Second week of June.
Yes.
Heard, Mr. Sharma, learned senior counsel assisted by Mr. P. N. Sharma, learned counsel for the petitioner, and Mr. Parasar, learned CGC. Heard in part, list the matter on 12 June as parted.
12 June.
Item 15.
But matter relates to compassionate appointment, my lord. My lord, his father while on service, my lord, he expired on 27/7/2013. And thereafter, immediately, my lord, on 28/2013, he applied for the compassionate appointment. Initially, he was recommended by the DLC, my lord, on 18/9/2014 for the post of grade 3, my lord. He was a HS pass, my lord. And he was recommended for grade 3 post. Thereafter, my lord, SLC meeting was held on 31/10/2015. In that meeting, his case was not placed.
Not placed.
No, not placed. For the reasons based on them, my lord. And thereafter, another meeting on 19/6/2018, another meeting of SLC was held, my lord. In that case, my lord, 104 numbers of cases were placed. And out of 104, only seven cases were recommended by the SLC. And other 97s, why they were rejected, it was not revealed, my lord. Thereafter, several writ petitions were filed by different.
Your name is in that 97?
97, my lord, no. They did not disclose the persons whose name were rejected. They disclosed only, they published a final list only consisting 7 numbers of candidates who were selected. 97, they did not disclose. Thereafter, several writ petitions filed, and ultimately one speaking order was passed pursuant to those order passed by this honorable court. Speaking order was passed on 22/11/2018. In that case, I was my lord, shown that lordship will find that page 51, my lord, my case. Page 51, serial number 66. Serial number 66, Dharani Soikia. I was rejected that already filled up with 5% quota and underqualified for 2 reasons. Then, my lord, he again
Your
filed
name is at serial number
66, my lord.
66. What is your name?
Dharani Soikia, my lord. So I was rejected on the ground that 55% quota has already been filled up and I was underqualified. So, my lord, I again approached this honorable court by filing a petition, my lord. Lordship will find the order passed by this honorable court at page 64, my lord. And it was, my lord, directed to the respondents as per office memorandum dated 1/6/2015, paragraph 15, that if my lord 5% quota directed to consider my case as regards other departments or other office also, my lord. I have annexed that, my lord, the office memorandum at page, lordship will find at page 54, my lord. And that particular paragraph, page 59. Serial number 15, lordship has find, my lord.
Page number?
Page 59, my lord. Page 59, paragraph 15. Lordship has got. If sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for compassionate appointment, it is open to the administrative department office to take up the matter with other departments, office of the government to provide an early appointment on compassionate ground to those in the waiting list. So, my lord, they can consider in other department or other office also. Accordingly, my lord, my petition was disposed of. Paragraph 66, my lord, directing the respondents to consider, my lord, as per this office memorandum. So they, my lord, again placed my case in the SLC meeting held on, my lord, 23/12/2019. Now, my lord, they have again, lordship will find that paragraph, page 73. My lord, lordship has found it, my lord. Serial number 19, my lord. First one, Dharani Soikia. They again rejected my, they have considered my case as regards, my lord, grade 4 post. And ground of rejection they have shown, Dharani Soikia cannot be accommodated within 5% cadre strength in this division. They have considered only in that division only, my lord. They did not consider in other departments or in other office. And second ground, my lord, they have stated that could not be recommended on the basis of financial need grade 4 candidates were selected on the basis of financial need, prioritizing economically weaker section first. So, my lord, they have taken another ground. This ground they have earlier did not take up. Now, my lord, they have taken up with this ground. And first ground, they have apparently, my lord, they have considered my case in that division only. They did not consider my case in any other department or in any other office, my lord. Now, my lord, they have filed an affidavit, my lord. In affidavit, they are trying to, my lord, justify the second ground, my lord. Second ground, so far the financial condition of my petitioner, my lord. They have said that 7 numbers of candidates were considered, and out of those 7, may I read, my lord? Lordship will find that page 2 of their affidavit, my lord, paragraph 4. May I read, my lord?
Yes.
That the statements made in paragraph number 15, 16, 17, and 18, 19 of the writ petition, the deponent states that the candidature of Sri Dharani Soikia was recommended for appointment on compassionate ground in grade 4 post by the concerned DLC in its meeting held on 18/9/2014. Subsequently, the case of the petitioner was placed before the SLC for consideration in its meeting held on 19/6/2018, but the SLC rejected the candidature on the ground that the candidate was underqualified, and also the candidate cannot be accommodated within 5% means for appointment on compassionate ground against the total club cadre strength of 34, grade 3, so and so, so and so. As the admissible quota is already filled up, the petitioner challenged SLC's decision in the Honorable High Court 5 WPC number so and so, wherein the Honorable High Court 5 order dated 27/5/19 directed to reconsider his candidature in the light of paragraph 15 of OM number 1 or dated 1/6/2015, and also in the light of order dated 1/3/2019 given in WPC number so and so, wherein directed to consider the case of the petitioner for grade 4 as per petitioner being HSLC. This is wrongly stated. I am HS, my lord, not HSLC. He is very much eligible for grade 4 post. In compliance to Honorable Court's order mentioned above, the candidature of the petitioner was again placed for SLC for grade 4 post, but his candidature was rejected on the ground that he could not be accommodated within 5% of the cadre strength in the division he applied. He could not be recommended to any office of PWRD in Assam on the basis of financial need, prioritizing economically weaker section first. There were 22 eligible grade 4 candidates, and there were only 7 vacancies of grade 4 posts in all over Assam to be filled up. Thus, as per Principle 5 and Principle 6 of the aforesaid OM, other candidates' financial condition was comparatively better than the 7 selected candidates. Moreover, at present, the monthly income of family calculated following Principle 6 of the aforesaid OM is more than 90% of gross salary of the deceased at the time of death. Therefore, the petitioner is not further eligible for compassionate ground appointment as per paragraph 9 of the aforesaid OM. Further, the candidature of the petitioner is considered for the second time. Therefore, no further consideration is required as per para 224B of the aforesaid OM. Monthly income of the 7 selected candidates' family and petitioners' family are given below. They have these 7 numbers were selected. And last one, petitioner, his income shown as 19,146. So, my lord, they have annexed a document, my lord.
So this income is one of the ground for consideration.
My lord?
Income is one of the ground for consideration as per office memorandum.
Yes, my lord. Financial condition. Yes, they have shown that my financial condition is better than the candidates, 7 numbers of candidates who were selected. They are trying to show, my lord. Lordship will find the page 6, my lord.
But
so for the ground number 1,
Hmm.
they have no justification.
Hmm.
Why they have not they have not considered my case in any other department or in any other office. There is no, my lord, justification, no explanation. They are trying to justify under the second ground, my lord. And both the grounds are diagonally opposite, my lord. If, my lord, I am, my lord, financially better in position, then my case need not to be considered, my lord. So question of 5% quota filled up does not arise, my lord. If I am financially better in position, so question of 5% quota, my lord, does not arise. So, my lord, they are trying to show, my lord, NXR A series, page 6. They have shown, my lord, lordship will find serial number, this the statement of, my lord, financial status of the petitioner. Serial number 14, they have shown my family pension as 14,635. And lordship will find serial number 21, monthly interest 8% from so and so, my lord. It is monthly interest they have shown as 4,511. And some of these, my lord, they have shown at serial number 29, my lord. Serial number 25, my lord, 19,146. So they have shown it to be my lord, annual income. And according to, my lord, them, all the 7 candidates who were selected, my monthly income is better than the other, my lord. So, my lord, I have filed a reply affidavit to that effect. Reply affidavit, I have stated, my lord, I have annexed the, my lord, my mother's bank account also, wherein my family pension has been shown as, my lord, 10,226 only, not 14,000, as they have said, shown. And lordship will see page 7 of my reply affidavit, lordship. This is the salary last drawn that July 2013. He died in the month of July 13, my lord. His last salary was 18,673.
Page number?
Page number 7, my lord. This bank account, my lord. Last salary drawn was 18,673. July 2013, my lord. Now, lordship may come to page 10, my lord. Page 10 was the, my lord, the calculation of family pension. The calculation of family pension was 10,700 at that time, my lord. Subsequently, it was, my lord, deducted, and it comes to lordship will find that page 12, my lord. Page 12, 28,621 family pension was 9,398. July 21, it was 9,328. And thereafter, September 21, it increased to 10,226. And October 21 also 10,226. So, my lord, they have shown, my lord, where from they have shown it that my family pension was 14,365. I don't know, my lord, where from they have shown it. But my family pension, apparently, my lord, I have annexed the document. And moreover, my lord, so far lordship has rightly pointed out that first ground, they have no justification. Why my case was not considered in any other department or in any other office. So, my lord, they ought to have considered, as per direction of this honorable court, my lord, they ought to have considered my case in any other department or any other office, my lord. Instead of doing that, they have summarily rejected my case. And my lord, our High Court in one case, my lord, considered that at least a compassionate appointment, my lord, at least, my lord, at least once, my lord, case should be considered on merit, my lord. And 5% quota already filled up, that cannot be considered as a, my lord, merit, my lord. In paragraph 2, my lord. Page 2 and paragraph 2. On the other hand, Mr. S.S. Roy, Learned State Council, by referring to the affidavit in opposition dated so and so, has submitted that the case of the petitioner was taken up and because of the lack of vacancy, his case could not be considered. It is further submitted that the application is pending for more than 2 years and no further consideration is contemplated. After hearing the parties, this court is of the opinion that for consideration of appointment on compassionate ground deserves at least one such consideration to be done on merit, on the claim, and as has been held in the number of similarly situated cases, rejection on the ground of lack of vacancy cannot be said to be consideration on the merits of the case. In view of the above, the present writ petition is disposed of by directing the state, that the case of the petitioner is required to be considered on merits as and when vacancies arises. It is needless to state that no facilities to facilitate such consideration, the respondent authorities may take resort of the guideline framed on 1/6/2015, which mandates that in case of lack of vacancy, exploring vacancies in other departments is also permissible. So repeatedly, this Honorable High Court, my lord, repeatedly saying that if, my lord, vacancies is not available in a particular department, they can consider it in other departments or in other office also, as per office memorandum. That is my humble submission.
Yes.
Lordship. 2015 office memorandum. A relevant portion, page 55, Lordship, in the writ petition. Paragraphs 5. Page 55, relevant portion, paragraph 5. In the writ petition.
Yes.
Yes, Lordship. Compassionate appointment is not a matter of right. It is clear, Lordship. And it will be subject to the fulfillment of all the conditions, including the availability of the vacancy laid down for such appointments under the scheme, Lordship. Lordship, what is the principle? Principle is that to sustain the family in immediate effect, Lordship. This scheme or the principle of the compassionate appointment is to justify the family with immediate effect, Lordship, after demise of the family, the employed family, Lordship. Now, Lordship, in the Debabrata Tiwari, Lordship, I would like to submit before this honorable court paragraph 35, Lordship. The ratio laid down by the honorable Supreme Court is that, Lordship, if due to the fault of the department also, the authority also, if the delay laxus is there, then the petitioner is not liable to petitioner is not considerable under this scheme, Lordship, compassionate appointment, Lordship. Now this matter is 2013, Lordship. And now it is, Lordship, almost, Lordship, it is 13 years, Lordship, 13 years, Lordship. Then, Lordship, how they has survived, Lordship. And the principle laid down in the Debabrata Tiwari, Lordship, it is very clear that in the event of the fault of the department also, the authority also, therefore, Lordship, Lordship, in my affidavit, Lordship, I categorically stated, Lordship, that due to the lack of due to the 5% quotas, Lordship, he was rejected first, Lordship, and accordingly, Lordship, it is not satisfied that his financial condition is better than others, Lordship. It is categorically stated in my affidavit, Lordship.
No, that's all right, but on what basis that calculation was arrived at?
Lordship, before that, Lordship, I would like to submit the Debabrata Tiwari, Lordship. Debabrata Tiwari is one of the clear judgment, Lordship. It is a ratio.
No, first, let us go to the reason assigned for rejection.
Lordship.
So despite the direction of this court, you have not considered his peer in other department.
That is not in the that is not available in my the instruction is not available, Lordship, because in the affidavit it is not written. This was not in the affidavit. Is no answer was given, Lordship, regarding that point, Lordship. Lordship may consider this matter as per the direction of the coordinate bench, recent coordinate bench judgment, Lordship.
Yes, Kolita.
Well, my learned friend has referred the office memorandum, my lord. Office memorandum, my lord, some persons they are, my lord, taken up and some person they are discarding, my lord. But one cannot approbate and reprobate at the same time, my lord. He is, my lord, adopting the paragraphs which are favorable to them, and he is, my lord, he wants to, my lord, set aside those paragraphs which are not favorable to them. In one paragraph, my lord, page 57, principle 4, it is stated that district level committee will meet once in 2 months on the last Saturday of second month. And state level committee also will meet once every 3 months.
No, you explain on what basis you have arrived at the conclusion that his monthly income is 19,146.
They have no justification, my lord, to that.
No, justification, Lordship. It is stated in the affidavit, but regarding how this calculation was made, that is not clear from the affidavit. It may be in the but that was not challenge under challenge in this case. That was not challenge.
It comes on later.
No, but that was not challenge, Lordship.
No. He has a file, his affidavit in reply.
Reply I have
He
filed.
has shown his
No,
bank passbook.
First of all, Lordship.
Showing his income is 10,000 like that.
Yes.
So affidavit in reply has been filed. The stand taken by you is controverted.
No, but in his writ petition, Lordship, there is no mention or any explanation regarding the how they are now survived from 2013 to till today, Lordship. That is not something that is required.
Case is pending since
No,
2018.
that is required, Lordship. What is the ratio? What is the principle of the compassionate appointment? The principle of the compassionate appointment is that to meet the immediate effect of the family, Lordship. Due to the death of the employee, Lordship. That is the principle. It is not the right. It is categorically stated in
Now
my
he
OM,
cannot
Lordship.
cannot take that ground because already this honorable court has directed them to place to consider my case.
No. That during that direction, the new judgment of the Supreme Court is not in that time. It is now. I am submitting regarding this Debabrata Tiwari case, Lordship. It is categorically stated by the Supreme Court if the fault of the authority, then also the petitioner is not entitled, Lordship. That is the ratio.
When there is a specific order from this honorable court.
That during that order, Debabrata Tiwari is not in stand, Lordship. Now it is in under.
Cover in the
No.
case.
The Tewari is always covered.
When there is a
No, no,
High
but
Court's order, in that case, that ratio will not come.
in your, during the High Court orders, the Devobrata Tewari is not, in stand. Devobrata Tewari was not delivered. Now, we are on Devobrata Tewari.
So, my lord, Lordship may do one thing, my lord. Lordship may direct them to consider my case afresh in the next SLC, my lord.
No, no,
That also can be done, my lord.
Yeah.
Because they have not complied with that order. Where they were directed to consider my case in any other department or any other office.
It may be
We
disposed
are
of, Lordship.
disposing of the matter.
Yes, my lord.
Item 12.
Obliged, my lord.
My part, I have well with my lord. Learned friend, he will, whatever affidavit he has stated, my lord.
Affidavit, we have specifically made a mention with regard to the fact that since he resigned and as per the provision of the CCS rules, he is not entitled for pension. With regard to the other aspect of the matter, he is saying that he is entitled for leave encashment and that has been not given to him.
This office memorandum,
Yes,
subsequent office memorandum,
yes.
which Mr. Mohanto has referred to.
But we have made a mention, if your lordship kindly see page number 3, annexure 7.
Page number?
Page number 3
His affidavit.
in the affidavit in opposition, lordship.
Yes.
And before that, lordship, paragraph number 2 in page number 2, with regard to the CCS rules, the relevant provision of the CCS rules. The deponent begs to state that as per Rule 39(6)(2) of the CCS leave rules, if a government servant resigns or quits service, he may be granted suo motu by the authority competent to grant leave, cash equivalent in respect of earned leave at his credit on the date of cessation of the service to the extent of half of such leave at his credit, subject to maximum 150 days. Till the date of resignation, earned leave to the tune of 124 days was at his credit to the petitioner. Accordingly, he has been paid a sum of rupees 14,200, 14,021. On account of encashment of earned leave, a sum of rupees 2,38,595, which pertains to final settlement of pay and allowances and arrears on account of grant of 6 CPC, including encashment of earned leave, was remitted to the petitioner. Now the relevant provision, lordship, 39(6)(8)(2) of the CCS leave rules is enforced. The deponent also begs to state that as per Rule 26(1) of the CCS pension rules, resignation from a service or a post, unless it is allowed to be withdrawn in the public interest by the appointing authority, entails forfeiture of past service. So we are basically on this particular aspect of the matter, as per the provision of the CCS rules, he is not entitled to pension because there was no public interest involved in such withdrawal. So entails forfeiture of past service. The petitioner had resigned from his own volition and not in public interest. Hence, his claim of pension is arbitrary and baseless. So we are basically on that aspect of the matter. And what my learned friend is saying about the limit encashment, and that has also been clarified with as per the provision of the CCS rules, lordship, in paragraph 2.
No, Mr. Mohanto has referred to this clause number 5.3 of the office
Some
memorandum.
amendment to the CCS pension rule. Annex 3 of.
What is your view on this point?
With regard to annexure 3, lordship, we made a mention in our affidavit in opposition. I'm just referring to annexure 3, copy of the office memorandum. It is in paragraph number 8, we have made a mention with regard to that, lordship. that the statements made in para 4 and 5 are false and baseless and irrelevant, hence denied by the respondent. The deponent states that the petitioner had served 13 years of service, but he had resigned from the service at his own volition. Therefore, merely serving 13 years of service does not make him eligible for any pensionary benefits. So this aspect of the matter is to be taken into account, Lordship. It is also stated that as per Rule 49(2) of the CCS pension rules, the petitioner is not entitled for any pensionary benefits because he has neither attained the age of 55 years nor he had attained the age of superannuation. Further, the statements of the petitioner at the Rule 49(2) of the CCS pension rules has been superseded with Government of India, Ministry of Personal Public Grievances, Pension, Department of Pension, such by office memorandum such as that is completely a wrong interpretation. Therefore, the statements of the petitioner are completely denied. So that aspect of the matter is not covering the provision which is so far as the 49(2) of the CCS pension rules is concerned. And he has not completed because the 13 years of service, the service that has been rendered by the petitioner is only 13 years. So in that view of the matter also, Lordship, he is not entitled for any pension. So this aspect of the matter with regard to the office memorandum, which has been referred to in Annexure 3 by the petitioner, is no way affecting the cause of the petitioner in any manner. Because if you wanna kindly see this particular annexure at page number 38. Date of effect, if you wanna kindly see this particular annexure, this is annexure number 3. The undersigned is directed to state that in pursuance of the government's decision on the recommendation of the 6th Central Pay Commission, the president is pleased to introduce the following modification, the rules regulating pension, retirement, death, service gratuity, family pension, disability pension, and ex gratia lump sum compensation under CCS Pension Rule 1972. And communication of pension under CCS communication of pension.
paragraph you were reading?
I'm just referring to this particular annexure, Lordship, the office memorandum, annexure 3, which the owner has just now referred to, 2nd September 2008. If you wanna kindly see the page number 40 of the pension, page number 40, 5.1. A government servant retiring in accordance with the provision of the CCS Pension Rules 1972, before completing qualifying service of 10 years shall not be entitled to pension, but he shall continue to be entitled to service gratuity in terms of Rule 49 of the CCS Pension Rule 1972. So entire aspect of the matter with regard to this particular provision 5.1, 5.2, 5.3, and 5.4, these are all related with the retirement of a person. But here in this case, this particular provision of the CCS rules, which has been referred in our affidavit in opposition, this particular aspect of the matter is connected only with regard to the resignation on the part of the petitioner, because he resigned after completing a completing service of only 13 years. So in that view of the matter,
There's a clause number 5.3.
Yes, Lordship.
The submission of counsel for the petitioner is based on this clause.
No, here in this case, in cases, that is why I refer to 5.1, Lordship. In cases where government servant becomes entitled to pension on completion of 10 years of qualifying service in accordance with Rule 49(2) of the CCS pension rules, pension in those cases shall be paid at 50% of the emoluments. Here in this case, whether he is eligible for pension or not, that has been clarified in our affidavit in opposition. Since he resigned from the service, that's why he is not entitled for pension. And this particular office memorandum no way Given in reflection with regard to the fact, those persons who has resigned from the service, they are eligible for pension, so far as 50% has been mentioned in this 5.3. So he is otherwise not entitled. Whereas the leave encashment is concerned, leave encashment, that has also been clarified in paragraph number 2, that in view of the provision of 39(6)(2), he is eligible for half of the leave encashment, and that has been given to him. So there is as such no illegality on the part of the responding authority, Lordship, and no case has been made out. And whatever he is eligible and entitled, that has been given to him. And in paragraph 3, paragraph 7, we have made a mention that that he was paid rupees 2,40,000, including leave encashment, is not correct. He was already paid 4,42,342, which includes the final settlement of the GPF and the final settlement of pay and allowances and encashment of earned leave of rupees 2,38,595. So all amounts which he is otherwise entitled, it has been given to him. 4,42,342. It paragraph number 7. লিখিছে। If you wanna kindly see the R3 and R4, is at page number 11 and 12 of the affidavit in opposition. Addressing to the petitioner, please find enclosed herewith SBI such and such bank draft bearing number such and such dated at January 2009 for a sum of rupees 2,03,747. And the next page, the R4 is with regard to the payment of a sum of rupees 2,38,595. So in total, it's an amount of rupees 4,42,342. So what is your submission on the rule 26? Officer of service on resignation.
I want to clarify one thing, my lord. Whatever my rule 26 is saying, it is entailing the past service. But in no way it is as whispered that regarding I am entailing the pension, my lord. Because the only my lord notification it is in broad by the Office Memorandum 2008, my lord. It is specifically mentioned regarding the pension, my lord. But the 26 they rely the entailing the past service means, my lord, if somebody is after serving the department is going for the another department, so they can claim that I have the experience of this person on the basis of that, my lord, is entitled for a job and my lord, and my lord, entitlement of job and other things. But in this case, they are saying the entire entailing the past service, not the pension, my lord. And it is very clear from the order, my lord, the rule 26. I have, my lord, in my quoted in my petition also. Lordship will come. My lord, the page number 18. Page number 18, my lord, it is point 4. It is saying the appointment authority may permit a person to withdraw his resignation in the public interest on the following conditions, namely, one, that the resignation was rendered by the government for some compelling reasons which did not involve any reflection on his integrity. It is very important, my lord, integrity on his integrity, efficiency, or the conduct, and the request for the withdrawal of the resignation has been made as a result of a material change in the circumstances which is originally compelled him to tender his resignation. My lord, kindly come to, my lord, the annexure 1, annexure 4 of my writ petition, my lord. This is my resignation, my lord. Why I resign my department, my lord? It is written in para. No, no, this is not, my lord. Resignation at page, my lord. Annexure 1, I'm sorry, my lord. Page 34. That was the circumstance under which I resigned, my lord. Kindly see, it is second para that I am availing the leave on and from 14/1/2008 owing to my mother's serious illness. But the at present her condition is deteriorated day by day, and there is no one to look after her treatment except me. In this pathetic situation, I have no way to leave the service to save my mother's valuable life. So my mother's life was very important than my service. That is why I resigned. And that is, my lord, after 10 years, that is completing 13 years. And nowhere in 26 rule, it is saying, my lord, lordship, I'll brought to lordship to rule 26 also, where nowhere it is saying that they, on resignation, before completion of the service, that is rule, my lord, it is, I have reflected on page 17 of my writ petition, 26. Forfeiture of the service on resignation. Resignation from the service as a post unless it is allowed to be withdrawn in public interest by the appointing authority entailing forfeiture of the past services. Then, my lord, a resignation shall not entail forfeiture of the past services if he has been submitted to take up a proper permission, another appointment, whether temporary or the permanent, under the government where the service qualified. And number 3, interpretation of the service in a case filing under the sub rule 2 due to the 2 appointment, because a certain 2 appointment may be taken at the same time, the being in a different stations, not exceeding the joining time permissible under this rule of the transfer shall be covered by the grant of the leave of any kind due to the government servant on the date of the relief of by the former condition to the extent to which the period is not covered by the leave due to him. Then, my lord, 4 is very important, my lord, where it is the appointment authority may permit a person to withdraw his resignation in his public interest. Again, I'll read, my lord, the last portion. This is whenever the situation was but a change, that opportunity that has been given to me, my lord, because my mother was at the time ailment was there, and after expiry of her, my lord, I was really free. So that was not exercised by them. So, my lord, so far the entailment of the past service is concerned, it is nowhere they have related.
No, Mr. Monto, whether after the demise of your mother, you have applied for
I have
withdrawing
not,
the resignation.
I have not applied because, my lord, I am not, frankly speaking, my lord, I am not aware that that provision was there. Because matter simply because of my ailment, mother's ailment, I sought the resignation from the department. But the department saying that the entitlement of the past service, not the pension, my lord, but the all the notification by which brought some amendment in view of the accepting the six pay commission, where it is saying that the pension specifically, my lord. But here is no way it is part that I am not entitled for the pension and entitlement of the service, past service, my lord. Service, entitlement of past service and the entitlement of the pension is a different two things, my lord. My humble service will be that, my lord. They are only insisting that the past service. I already, madam, I have not entitled for past service, but the pension. And whenever they brought the amendment by accepting the six pay commission, by which specifically stated the on completion of 10 years minimum service, I am entitled to full pay, full or my lord, full emolument of the half of the emolument or the average of the emolument which is beneficial for me. This is my humble submission. My lord, on that aspect, my lord, I am entitled for the pension.
Pardon?
My lord.
Pardon? Pardon?
My lord, on the basis of this, my lord, I am entitled for pension, my lord. This is my humble submission, my lord. Everything is before lordship. Lordship can consider, my lord, these things, my lord. This regarding the entitlement pension is not there. They are saying only all the aspect. They are insisting on that the entitlement of the my lord, past service. But in no way it is mentioned that the whisper of that the pension word. But the all the office memorandum, all the pension, CCS pension rule, they are insisting on the provisions. They specifically mention the word pension. But it is no way it is mentioned the pension. This is my humble submission, my lord. Pension and the service is a totally different thing, my lord.
Okay. Yes, Mr. Sodhure, anything to submit?
No, Lordship, we have clarified everything in our affidavit. Past service, if the past service is not counted, then the pension will not come. So this has been clarified by the provision of the CCS rules also. So there is no confusion so far as the points raised by the petitioner is concerned. And all the payments which the petitioner otherwise entitled, everything has been given to him. There is no dispute with regard to that.
Regarding my lord, the encashment of the leave encashment,
No,
that is,
that-
I am
that has
still
also-
disputed, my lord. 124 days leave encashment are there. That means if it is counting in the month wise, that means 4 months. So 4 months salary cannot be, my lord, one person at 10,000 rupees, my lord, to give the 40,000.
The leave rules is very clear. We have annexed it as annexure number 1 in the affidavit opposition, Lordship. Lordship may peruse it and pass a copy. R1, Lordship, it has been specified.
Okay. Heard Mr. Monta, learned from the court of petitioner and Mr. S.P. Sodhure, learned CGC. What I said. The argument concluded, order is that.
Masala.